Hello everyone, so welcome back to English Law. So I'm going to carry on with trespass to the person. And remember, there are a number of conditions to be satisfied for it to be held to be trespass to false imprisonment. Number of conditions for it to be satisfied. It's got to be total restriction of movement. It must be intentional, and it must be unlawful. So let's come to the unlawful aspect of that. So there are some civil liberty parts to this issue, false imprisonment, that have arisen since the passage of the Human Rights Act 1998. The European Court of Human Rights has been a major force in influencing judicial rulings on this one. So Article 5, that's the right to liberty under the European Convention on Human Rights, was held to be applicable in R against Burnwood Mental Health Trust ex parte L in 1999. That went to the House of Lords, which of course was the Supreme Court before the Supreme Court as such was established. So there was a majority decision there, which is quite contentious, against the claimants by the House of Lords. Anyway, there was a result against the UK in House of Lords versus United Kingdom, 2005. So there was legislation to sort out the issue, Mental Capacity Act 2005. Remember, people can be sectioned. You can be detained against your will in a psychiatric hospital if two psychiatrists sign a document attesting that they believe that you are a danger to your own life or to that of those around you. You're so badly mentally ill that you have to be held there against your will. Obviously, we have to be cautious about this because we don't want people who are only somewhat mentally ill being locked up when that's unnecessary. Okay, so another key case here is Austin against Commissioner of the Police for the Metropolis. 2009 went to the House of Lords. The police of the Metropolis, that's the London Police, the Metropolitan Police, the Met, as we say for short. And there was a G20 summit in London in May 2001, as in the 20 largest economies were represented. And some anti-globalization ultra-left protesters were trying to stop these world leaders improving the world economy. Anyway, many people, the police were attacked. There were attempts to murder the police, throwing things at them during this. Fortunately, no police officers were killed. It was heavy violence. So police intelligence found out that there was going to be an attempted riot, and there was a threat to public order. People could have been killed. A lot of public property would have been destroyed. So the crowd control strategy was used by the police called kettling. And that's to create a cordon to not allow people in or out. Have those high metal barrier things all attached together, the police in riot gear. You can't get in and out for hours. What if you need to do a number one, number two? Tough. You're ending up doing it on the street. Some people who were not involved in protest, just happened on the street, were caught there for hours, for 7 hours, and so they were detained against their will in a sense. So they claimed that this was false imprisonment. This was overturned in domestic courts. The case was sent to the European Court of Human Rights. They claimed that holding them in the cordon was actually taking away their liberty under the Article 5.1 of the Convention. So the court in Strasbourg, that's the European Court of Human Rights, looked at the application of the Convention around kettling and what the police had done in order to uphold public order. They concurred with the House of Lords in Austin and others against the United Kingdom 2012. The Grand Chamber of the European Court of Human Rights found that, considering the particular facts of the case, the kettling was not deprivation of liberty, and Article 5 was therefore inapplicable here. So that, generally speaking, the police trap people in a street for 7 hours. Yeah, that would be enforced imprisonment. That would be taking away your liberty. However, bearing in mind the significant threat of heavy violence by far-left rioters, then this was a proportionate measure adopted by the police. It was permissible in democracy. The court said the following: it must be underlined that the measures of crowd control should not be used by the national authorities directly or indirectly to stifle or discourage protest, given the fundamental importance of freedom of expression and assembly in all democratic societies. Had it not remained necessary for the police to impose and maintain the cordon in order to prevent serious injury or damage, the type of measure would have been different, and its coercive and restrictive nature might have been sufficient to bring it in within Article 5. So, considering the criminal justice system continues to affect the law on false imprisonment, there's R on the application of Jallar against Secretary of State for the Home Department 2020. This was about what exactly false imprisonment is, and is it the same as deprivation of liberty under Article 5. So the claimant here had been under a night curfew for 2 years and was tagged, this electronic thing on his leg, the police can find him wherever he goes. And if you cut it off, that sets off an alarm. They later found there was no lawful authority for giving him this curfew. And the claimant moved an action for damages because he'd been falsely imprisoned, because he wasn't allowed out at night. So Lady Hale, who was present at the Supreme Court at the time, she gave her ruling, and she said that there is no question the defendant had defined the place where the claimant had to stay between 11 at night and 7 in the morning. And there was no way he could go somewhere else during those hours without the Secretary of State's specific permission. The claimant broke this curfew occasionally, but that didn't change the situation that he was usually obeying it, and whilst he was obeying it, he was falsely imprisoned. So, although it was possible for the claimant to walk out, then he would have been in trouble if he did. And he was complying with the order mostly not because he wanted to, but because he had to, because he feared the consequences of disobeying the order. So he was wearing electric tag, so if he left his house, the police would realise. So this is detention or confinement under the common law ruling, because some people would hope to say, well, he's not locked in the house, so therefore it's not confinement. So the court held in favour of the claimant. The Supreme Court turned down the opportunity to make the common law definition and the more nuanced definition of deprivation of liberty under the Convention the same. There remains a gap between them. False imprisonment and deprivation of liberty are not quite the same thing, though they somewhat overlap. So there are a number of defences to trespass to the person. Well, what are they? So there are statutes which allow certain people in particular situations to do something which would otherwise count as trespass of the person. For example, the Police and Criminal Evidence Act 1984 confers the police on powers of arrest, is very specific about this, and says that this is not false imprisonment, this is not battery. If you have to lay hands on people, you have to use reasonable force in order to apprehend them and effect an arrest. Mental Health Act 1983 allows for obligatory admission to hospital, even against the will of the patient in a mental health situation. Okay, how about consent? Some touching which would be battery, but there's consent, so it's not. If the claimant expressly says it, yes, you can touch me here or there. And Nash and Sheen, there was a case, trespass if there's a deviation from the right procedure. The person agreed with you to do one thing, but you actually did something else, so it's still trespass. As in, it was the wrong hair treatment. Medical treatment often involves the direct application of physical contact, and sometimes it's without the patient's consent. So if you're giving treatment different from what the patient has agreed to, well, then that could be battery. In Chatterton against Gerson, 1983. Here the plaintiff had serious pain, and her doctor gave her spinal injections, which reduced the pain for a bit. Her right leg then lost feeling. So she said this is trespass because she'd agreed to the injection, and agreement to the injection was invalid because she hadn't been told about this possible side effect. The defendant was held not to be liable in trespass because if the patient is informed in general terms about what the treatment is, then that is a valid consent. And not mentioning all the risks doesn't vitiate the consent. But even when the consent is proper to a claimant trespass, you have to bear in mind that an action about the doctor's failure to disclose relevant information means that the treatment might be regarded as negligent. So there's also implied consent to battery in situations where, in sports, for example, there's going to be some physical contact, such as in rugby or football, R against Billinghurst 1978 or Condon against Bassey 1985. Okay, that's reasonably expected, and this only applies to non-negligent behaviour. If you break the rules of the sport and punch somebody or kick somebody, well, no, that is trespass or assault. In one case, somebody had a broken leg as a result of a foul tackle in a game of football, but because it was a foul, that was trespass of the person, and indeed it could be assault. In Watson against British Boxing Board of Control 2001, it was found that although a boxer is consenting to be punched whilst he's in the ring, he doesn't consent to injury arising from any lapse in ringside safety. So for the consent to be proper, the person has to have the capacity to consent, be of a certain age, 16 or over in many cases, be of sound mind, and all the rest of it. be told about what substances might be administered, if they're going to get an injection or something, what are the potential downsides of this, as well as the benefits of what the proposed injection or something. So capacity is something which the law presumes is a rebuttable presumption. If you can show the person lacked capacity by being underage, by being mentally subnormal, by being mentally ill, then that consent will be overturned. So the law on capacity is highly complicated. For example, there's consent and the refusal to consent are different things. Anyway, but I don't need to go into that. Common law has a key case here, Ray F. 1990, and the Mental Capacity Act 2005 sets this out in some detail. That's enough at the moment. Toodaloo.